All right, this hearing will please come to order. I am Dr. Kathy Riekman, the Board Chair of the New Mexico Chiropractic Board. I will be acting as the presiding officer for this rule hearing. The purpose of this hearing is for the Board to receive public comment on proposed amendments to the Board's current rules and regulations. The Board welcomes everyone present at this hearing. This hearing is being conducted pursuant to and in accordance with the provisions of the Chiropractic Physician Practice Act, NMSA 1978, Section 61-4-1 to 61-4-17, the Open Meetings Act, Sections 10-15-1 through 10-15-4, the Uniform Licensing Act, NMSA 1978, Section 61-1-29 through 61-1-33, and the State Rules Act, NMSA 1978, Sections 14-4-1 through 14-4-11. The New Mexico Lobbyist Regulation Act regulates activities before boards and commissions in rulemaking proceedings. Contact the Secretary of State's office for information and registration. Public notice of this hearing was advertised in the New Mexico Register and the Albuquerque Journal. Copies have been available from the board office since the notices were published and are available to the public attending this hearing. Copies of the proposed rules were also published on the board's internet website at www.rldstate.nm.us and were available by request to anyone who requested them. May I remind everyone to sign the attendance sheet that will be entered as an exhibit into the record of this hearing. We've already asked somebody to watch the back door to make sure people sign in as they come in. Let's do some introductions here. Let the record show that the following board members are present. Would you please introduce yourselves?
Dr. Michael Pendleton.
Dr. Brad Fackrell.
Wayne Goforth.
Dr. Kathy Frescas Chavez.
Dr. Riekman.
Delilah Tamario, Assistant Attorney General from the Attorney General's Office.
She is here to advise the board. Also present are Nicholas Alderete, the board administrator, Lilia Urrutia, board administrator lead, and Martha Gallegos, team leader for boards and commissions. For the record, would the members of the audience please introduce themselves and state their affiliation?
Dr. Steve Perlstein, chiropractic physician.
Dr. Michael Pridham, chiropractic physician in Albuquerque.
Diana Statsula, Executive Director with the NMCA.
Dr. Ryan Rouse, President of the NMCA and practicing chiropractor in Farmington, New Mexico.
I'm Dr. David Peer, the immediate past president of the NMCA.
My name is J.D. Bullington. I'm a registered lobbyist for the Alliance of New Mexico Chiropractors and Government Relations Consultant.
Dr. Christina Lujan, sports medicine chiropractor in Albuquerque, New Mexico, and the NMC's treasurer.
Dr. Blair Alexander, chiropractor in Albuquerque.
Dr. J.C. Moore, Vice President of the New Mexico Chiropractic Association and practicing chiropractic provider in Albuquerque.
Brian Dickert, private practice in Corrales, New Mexico, and Vice President of the ANMC.
Dr. Dean Wasson, practicing chiropractor in Rio Rancho, New Mexico.
Dr. Noreen Sullivan, and I'm a practicing chiropractic physician in Santa Fe, New Mexico.
Lori Siaka, Board Administrator with Regulations and Licensing, just sitting in to witness.
Noel Martinez, I'm with the Legislative Finance Committee of Montes Colanos, so similar, I'm just sitting in.
Tom Larison, chiropractor in Albuquerque.
Linda Siegel, lobbyist representing the chiropractic path.
Priscilla Garcia, what am I? Director, Boards and Commissions. Sorry, just blanks out.
Good morning, I'm Gloria Regensburg, attorney for the boards and commissions.
Catherine Ortiz, Deputy Director for Boards and Commissions.
Thank you very much. This is a formal proceeding, and a court reporter is present to record the proceedings. The transcript will become a part of the rule hearing record. Therefore, when a person is recognized to address the board, you are asked to identify yourself for the record each time you address the board, and to speak loudly and clearly so the recorder can pick up your comments. This hearing will be conducted in the following manner. Nicholas Alderete, Board Administrator, will present exhibits to the board. I, as the presiding officer, will rule on the admissibility of the exhibits offered for admission after allowing questions from members of the board. Exhibits admitted into evidence are available for review by members of the public. However, exhibits may not be removed from the room. After Nicholas Alderete, Board Administrator, offers exhibits and their admission has been ruled upon, I will open the hearing for comments from the audience. We will proceed in numerical sequence through each proposed rule. Do you want me to go on with the script, or do you want to do the exhibits? Okay, I'm sorry. This is my first time doing this. We will address only one rule at a time. However, you may refer to other rules that reasonably relate to the rule being discussed, or which relate to your comments. The Chiropractic Board does not follow the rules of evidence, but shall, in the interest of efficiency, reserve the right to limit all testimony being irrelevant, redundant, or unduly repetitious. The decision as to whether such testimony is irrelevant, redundant, or unduly repetitious shall be made by me as the presiding officer. And basically, redundant means if somebody else has already presented the information that you want to get up and present, for the sake of time, it would be much better if you would just say, Dr. So-and-so presented what I was going to present, and I agree with Dr. So-and-so. Okay? May I have a show of hands on the number of people who intend to testify or comment on the proposed rules? Somebody want to count? 1, 2, 3, 4, 5, 6, 7, 8. You get 10? Okay. All right. We discussed this, the Assistant Attorney General and I. We will limit your speaking to 5 minutes. And again, I encourage you to, if somebody else has already presented what you're presenting, to just get up and say that you agree with the previous doctor. After a person has testified or offered comment, I will permit board members to question that person. Any member of the audience wishing to question that person may do so after being recognized by me, the presiding officer, after identifying themselves for the record. At the conclusion of this rule hearing, the board will hold its meeting where board members will conduct discussions and take final action on the rules such as amending, adopting, or tabling them. So during the rules hearing, we will not be making decisions as to, what we're accepting or acting on, what we might table. That'll be done in the regular meeting after the rules hearing. I would encourage the board members, if you have questions, to ask questions, but we're not going to get into, long-winded discussions. We're seeking information is what we're doing during this rule hearing. So, I think we're at the point of having the exhibits entered into evidence.
Madam Chair, I have a question.
Yes, sir.
What you just had stated, so we're going to vote on this in the meeting afterwards. Is that
Yes.
still open to the public at that time?
Oh, yes. Absolutely.
Thanks.
All right. This public hearing is now open. Mr. Alderete, at this time, do you have any exhibits to introduce into evidence?
Hearing Officer Dr. Kathy Rickman, I have the following exhibits to enter into evidence. Exhibit 1, the legal notice published in the New Mexico Register. Exhibit 2, legal notice published in the Albuquerque Journal. Exhibit 3, notice sent to interested parties. Exhibit 4, proposed amendments to the Board's Rule Part 1 of 16.4 NMAC entitled General Provisions. Exhibit 5, proposed amendments to the Board's Rule Part 2 of 16.4 New Mexico Administrative Code entitled Temporary Licensure. Exhibit 6, proposed repeal and replace of the Board's Rule Part 3 of 16.4 NMAC entitled Requirements for Licensure. Exhibit 7, proposed repeal and replace of the board rule, Part 4 of 16.4 NMAC entitled Licensure without examination. Exhibit 8, proposed repeal and replace of the board's rule, Part 5 of 16.4 NMAC entitled Criteria for Determination of Equivalency to Council of Chiropractic Education, CCE. Exhibit 9, proposed repeal and replace of the board's rule, Part 6 of 16.4 NMAC entitled Exemptions. Examinations. Sorry. Exhibit 10, proposed repeal and replace of the board's rule, Part 7 of 16.4 NMAC entitled Impaired Practitioners Program. Exhibit 11, proposed repeal and replace of the board's rule, Part 8 of 16.4 NMAC entitled Disciplinary Proceedings. Exhibit 12, proposed repeal and replace of the board's rule, Part 9 of 16.4 NMAC entitled License Renewal Procedures. Exhibit 13, proposed repeal and replace of the board's rule, Part 10 of 16.4 NMAC entitled Continuing Education. Exhibit 14, proposed repeal and replace of the board's rule, Part 11 of 16.4 NMAC entitled Forfeiture of License. Exhibit 15, proposed repeal and replace of the board's rule, Part 12 of 16.4 NMAC entitled Classifications of Chiropractic Licensure. Exhibit 16, proposed repeal and replace of the board's rule, Part 13 of 16.4 NMAC entitled Reinstatement of Chiropractic Licensure. Exhibit 17, proposed repeal and replace of the board's rule, Part 14 of 16.4 NMAC entitled Management of Medical Records. Exhibit 18, proposed repeal and replace of the board's rule, Part 15 of 16.4 NMAC entitled Chiropractic Advanced Practice Certification Registry. Exhibit 19, proposed repeal and replace of the board's rule, Part 16 of 16.4 NMAC entitled Parental Responsibility Act Compliance. Exhibit 20, proposed repeal and replace of the board's rule, Part 17 of 16.4 NMAC entitled Supervision of Interns. Exhibit 21, proposed repeal and replace of the board's rule, Part 18 of 16.4 NMAC entitled Practice Procedures. Exhibit 22, proposed repeal and replace of the board's rule, Part 19 of 16.4 NMAC entitled Chiropractic Assistance. Exhibit 23, proposed repeal and replace of the board's rule, Part 20 of 16.4 NMAC entitled Advertising. Exhibit 24, proposed repeal and replace of the board's rule, Part 22 of 16.4 NMAC entitled Fees. Exhibit 25, proposed repeal and replace of the board's rule, Part 23 of 16.4 NMAC entitled Licensure for Military Veterans and Spouses and Veterans. Exhibit 26, comment from Dr. Stephen Perlstein. Exhibit 27, comment from Diana Statsula. Exhibit 28, comment from Diana Statsula. Exhibit 29, comment from Dr. Bobby Perea. Exhibit 30, comment from Dr. David Peer. Exhibit 31, comment from Dr. George Simmons. Exhibit 32, comment from Dr. Jeremy Rouse. Exhibit 33, comment from Dr. Laura Hobson. Exhibit 34, comment from Dr. Ryan Rouse. Exhibit 35, comment from Cindy Reed. Exhibit 36, comment from Dr. David Peer. Exhibit 37, comment from Dr. Mark Mudd. Exhibit 38, comment from Tommy Larson. Exhibit 39, comment from Dr. Jeremy Rouse. Exhibit 40, comment from Dr. Robert Jones. Exhibit 41, comment from Dr. J.C. Moore. Exhibit 42, comment from Dr. Harvey Johnson. Exhibit 43, comment from Dr. Ryan Rouse. And Exhibit 44, comments from Regulation Licensing Department.
Are there any questions from the board members?
I have a question.
Please identify yourself.
I'm Dr. Michael Pendleton,
Okay.
and the question is, the letter we received here from Ms. Garcia, when is that going to be, is that going to be addressed?
In the regular board meeting. Any other questions? All right. Exhibits 1 through 44 are hereby admitted into the record. Mr. Alderete, are there any other exhibits to enter into the record this time?
Hearing Officer Dr. Riefman, there are none.
All right. Any persons wishing to testify who wish to submit evidence with their comments shall do so when they are recognized to testify. Each document shall be introduced as an exhibit into the record. Board members will be permitted to ask questions before I rule on the admissibility of the evidence. Upon admissibility, each exhibit will be marked and numbered and entered into the record. At this time, each proposed rule will be introduced in turn into the record. I will open the floor to members of the audience for testimony and comments on each rule. Members of the board or of the audience may ask questions of each witness upon being recognized to speak. However, any discussion by the board will be held during the regular board meeting following. To expedite the day, many of these sections, the only thing we're changing is the name of the board. I'm sure you all who've been around a long time, we have all been used to saying the New Mexico Board of Chiropractic Examiners, but that's not how the board is actually named in the statute. So at the advice of Assistant Attorney General, I guess, we have gone through and changed New Mexico Board of Chiropractic Examiners to comport with our statute, which is New Mexico Chiropractic Board. So almost every section, that's why we're addressing it. We may also be addressing spellings, corrections in spelling, references to the board. So rather than, and I'm sure you will all appreciate that, rather than us reading the entire rule front to back, we will just skip to the places where we're making corrections. Is that correct? Is that acceptable?
Excuse me. Madam Chair, members of the commission, audience members, I think at this point what would be required for this rule hearing is just to read out the New Mexico and Administrative Code citation plus the part general provisions, and then ask the audience if there's any comments within that particular one.
Okay. So in other words, just read the Chapter 4 Chiropractic Practitioner, Part 1, General Provisions, 16.4.1.
Yes.
Okay. All right, so we will start with Part 1, General Provisions. Does anybody have any comments on any of the changes within a particular part one? Any comments from the public? If not, let the record show there were no comments, and we'll move on to part two. Part two, Title 16, Chapter 4, Part 2, temporary licensure. Are there any comments from the public concerning the changes made within this particular rule? Let the record show there was no one from the public that wished to make comment on this particular section. We will move on to Title 16, Chapter 4, Part 3, requirements for licensure. Are there any comments from the public concerning this? All right. Shall we just find out how many there are and ask them to come forward? One at a time.
For each particular.
Yeah, well, on this part, we have one hand up. I didn't see any others. Okay, so we just have them, yes. Two, okay. Whoever wants to go first, please stand up very clearly and loudly, give your name and make your comment, and please hold it to 5 minutes.
My name is Dr. Stephen Perlstein, and I have a comment about 16.4.3.9, the new licensee presentment to the board. As I read this rule, I had a question, which was why? There's nothing in the rule that says why a new licensee needs to come before the board. If it is of the nature of explaining to the new licensee how the board works, and things like that, I think it either needs to be in the rule, or the rule needs to be scrapped and there needs to be another way of educating the new licensees as to how the board works. I have been on the board, and I absolutely support having new licensees, in fact, old licensees, know and understand fully how the board works, all about rules, hearings, etc., etc. Perhaps there's another way of doing it than to have them come. And there's also, for many, that could be a financial hardship. Even though you're giving lots of time for them to appear, it could be a financial hardship for somebody from Las Cruces to come up to either Albuquerque or Santa Fe. So there's something about this rule that either needs to be embellished or scrapped for the reasons that I've explained. Thank you.
Madam Chair, members of the board, and distinguished guests, my name is Dr. Michael Pridham. I'm a chiropractor in Albuquerque. I chair the New Mexico Overdose Prevention and Pain Management Advisory Council's Integrative Medicine Committee. I'm an attending chiropractic physician at the University of New Mexico's Department of Neurosurgery, and I treat patients at First Nations Community Health Source, which is a federally qualified health center in Albuquerque. I have had a question about whether or not the executive decision that the previous governor made still stands, that you can't add a new rule until you take away an old rule. And for this particular part, I thought that teleconferencing should be available for the new applicants to be able to Skype in so that they don't have to drive from Silver City or Farmington. Thank you.
Do any of the board members have questions for either one of the speakers?
I do. Dr. Michael Pendleton, question for Dr. Michael Pridham. Dr. Pridham, you asked about adding a rule and then removing a rule. Were you asking a question? Did you want to answer now, or are you asking? You said we're adding a rule, and then you asked there should be a rule removed due to that executive order from past governor.
Yes, I was
want to answer on that
from the AG. perhaps?
At this time, what we know about the executive order is that it remains in place for a number of boards that have been represented by the Attorney General's office. While it's not an official position, we are aware that it raises some concerns regarding a board's statutory authority and the executive order without any kind of legislative support usurps certain authorities that the boards and commissions have in New Mexico under their statute. Specifically for the Board of Chiropractic Examiners, they do have a provision within their rules that allows them to create or to establish and adopt rules that are would be helpful in carrying out the provisions of the Chiropractic Practices Act. There's nothing in my review of that statute that I see that, would prohibit them from doing that. Certainly, with the governor's executive order, it still is in place until that happens, until there's some more clear definition or authority or whatever, or if it's repealed. I believe that it does at some point operate to take away board authority without any kind of legislative approval, and that's the issue that we have with that at this time. We're not ignoring it. It is something that has been discussed and it continues to be discussed. With the new administration, I don't know what will happen with those executive orders. I know that there have been a number of executive orders that have been issued since that time. It is something that we have thought of and the board has considered, and we appreciate your comments. Certainly with comments from other members of the audience. If that answers your question. It is.
Can she add more rules without taking out rules?
Can the board add more rules or the governor add more rules?
The board.
The board has the authority under their statute to create and establish and adopt rules to carry out the Chiropractic Physician Practices Act. And that's the authority for this board to establish new rules. The executive order, I understand, has a competing interest, and it's not clear whether the executive order can take away authority of the board to create or establish rules when that authority has been given to them by the legislature. I think that's a more clear answer. That's where I was going.
Thank you.
Thank you.
Is there anyone in the audience that wishes to question either Dr. Pearlstein or Dr. Pridham? Okay. So, if there are no more comments or questions, let the record show that we are moving on to Title 16, Chapter 4, Part 4, Licensure Without Examination. Are there any comments from the public on this particular part? Let the record show there are no comments from the public. So we will move on to Title 16, Chapter 4, Part 5, Criteria for Determination of Equivalency to Council of Chiropractic Education. Are there any comments from the public on this particular part? No comments from the public, so let the record show we're moving on to Chapter 4, Part 5. No, that's what we... Okay, equivalency. All right, I'm sorry. We're moving on to Chapter 4, Part 6, Chiropractic Practitioners Examinations. Do we have any comments from the public on Part 6? No comments from the public, so let the record show we're moving on to Part 7. Chapter 4, Part 7, Impaired Practitioner Programs. Any comments from the public on this particular part? Comments from the public, so let the record show we're moving on to Title 16, Chapter 4, Part 8, Disciplinary Proceedings. Are there any comments from the public on Part 8? All right, let the record show no comments from the public on Part 8. We will move on to Title 16, Chapter 4, Part 9, License Renewal Procedures. Do we have any comments from the public on Part 9? All right, let the record show no comments from the public on Part 9. So we will move on to Title 16, Chapter 4, Part 10, Continuing Education. Do we have any comment from the public on Part 10? Okay. Any other hands up? We just have the one. All right. Doctor, please stand, give your name clearly, and you have 5 minutes.
Yep. My name is Dr. J.C. Moore, chiropractor in private practice. I'm curious if the board or the RLD is planning on adding additional staff to the chiropractic board and with the adoption of this rule. Currently, there seems to be a backlog of approval of continuing education units and courses there. I'm concerned by removing chiropractic colleges providing educational opportunities as well as various organizations that there will be even more courses that necessitate approval and that this process will take even longer. I currently had experience with this, trying to get some online courses approved, and was advised by the board staff that it could be up to 90 days, and that's at the current level. So again, I have concerns, and I'm wondering how the board plans to address the increased number of applications that now must be presented. Thank you.
Thank you, Doctor. Do the board members have any questions for the doctor? No? Anybody in the public have a question for this doctor? All right, thank you. Okay. All right, so let the record show that we're moving on to chapter Title 16, Chapter 4, Part 11, Forfeiture of License. Are there any comments from the public concerning Part 11? All right, moving on, let the record show we're moving on to Title 16, Chapter 4, Part 12, Classification of Chiropractic Licensure. Are there any comments from the public on Part 12? There are no comments from the public on Part 12, so let the record show we're moving to Title 16, Chapter 4, Part 13, Reinstatement of Chiropractic Licensure. Do we have any public comment on Part 13? No comment from the public on Part 13. We will move to Title 16, Chapter 4, Part 14, Management of Medical Records. Do we have any comments on Part 14? All right. No comments on Part 14. We will move to Title 16, Chapter 4, Part 15. I know we're going to have comments from the public on that one. How many hands, show of hands, how many want to speak? 1, 2, 3, 4, 5. Okay. 6. 5 minutes. So you will each be given 5 minutes. However, I will remind you, if you're going to say the same thing that doctors in front of you said, that's redundant. Please just stand up and give your name and say that you agree with the other presenters that have already presented. So,
Can I ask a question of clarification?
yes, sir.
So it's 5 minutes for the entire rule, or are we allowed 5 minutes for individual pieces of this?
You have 5 minutes to speak.
Thank you.
Set my timer.
Good, we'll make you the official time.
I'm Dr. David Peer. I respectfully, and if I can just pause on the word respectfully for a minute, I honestly respect everything that all you doctors do, not just every day for your patients, but also for our profession. I believe what you and I have in common outweighs our differences. At least it does in my heart. I just want to say that. I do respectfully request that the board chair, Dr. Kathy Riekman, recuse herself from any and all discussion and any and all voting in the meeting that will follow this public hearing on the rules that affect the advanced practice registry. The advanced practice
Please keep your
certification.
comments specifically to what you support or do not support in this Part 15.
I will. My request that the board chair recuse herself is based on a claim of extreme bias.
Dr. Peer, please keep your comments specific to the rules hearing and the rule that we're talking about.
I'm going to.
No, you're not. You're bringing up, an issue with the board and board members. You need to keep your comments to the rule.
I was advised by my attorney that I was allowed to speak here today.
This is a rule hearing. That's the type of thing you can bring up at the regular board meeting.
Okay.
But at a rules hearing, you're supposed to be speaking to whether you agree or disagree with the proposed rules and why or why not.
Okay.
Okay, so keep your comments to that.
Thank you. The proposed rule that limits an advanced practice chiropractic physician's ability to mix injectable medications just prior to administration in our office is limiting our ability to provide a remedy to our patients. It is not required of any other healthcare professional. And quite frankly, the fact that Dr. Riekman brought this rule up personally, in my opinion, is an abuse of her discretion.
Keep your comments.
It makes the rule, this rule, arbitrary and capricious, and is against the weight of the substantial evidence of the record, because the claim has been this is a public safety issue, and our record is nearly immaculate. We have one of the most amazing safety records, the advanced practice chiropractors in our injectables. In 10 years, there's been one adverse event, and it had nothing to do with the mixing or the compounding of substances. It was a sterile technique issue, and we've added education on sterile technique to every advanced practice certification. This rule, and this will be my final statement, is arbitrary and capricious, against the weight of the evidence, and is, in my personal opinion, an abuse of the discretion of the chair. Thank you.
All right, who would like to speak next?
Madam Chair, members of the board, Dr. Ryan Rouse, Farmington, New Mexico. I'm a bit of a rule follower by personality, I suppose. And as I read through the rules that were being changed in regards to how we practice our advanced practice procedures, especially whenever we were talking about the compounding or the mixing of more than one ingredient to administer via injection to our patients, my immediate thought was to go back to rules that the rest of our medical colleagues must abide by. So I went to the RLD website, very simple, and I started digging through hundreds of pages of practice acts from all other medical providers who are allowed by statute to deliver injections. And I was specifically looking for the terminology that we have in this proposed rule, compounded substances prepared by a certified licensed compounding pharmacy. So I dug through medical board rules in their Practice Act, Doctor of Osteopathy, Practice Act rules, New Mexico Nursing Practice Act and rules, New Mexico Podiatrists rules directly out of their Practice Act, the Board of Pharmacy directly, and specifically as it relates to sterile compounding, New Mexico Board of Veterinary Medicine, directly from the RLD. The naturopathic rules, as they are listed under the medical doctor's rules. The physician assistant rules. And last but not least, the dental practice rules. Out of all of these hundreds of pages that I dug through, there was not one, not a single instance where this verbiage would be utilized in any other practice act for any other medical professional who administers injections to their patients in their offices. This rule is arbitrary, it is arguably capricious, and this rule should either be tabled or removed completely.
I'm Tom Larison. I'm a...
Could I ask you to come?
Sure.
forward? Thank you.
Sure. I'm Tom Larison. I'm a doctor of chiropractic in Albuquerque. I have a rather unique position here in that my practice is an independent practice located in the office of an interventional pain specialist. So I observe procedures with injections every day, and I have worked with other, I also work with a neurology, MD neurologist that is also a pain specialist. And I have never experienced, through observing what they do, I've never experienced them having a problem with compounding in the same method that we have been taught as doctors of advanced chiropractic practice. I feel like it would be such a, first of all, just a burden on the patient themselves, because the patient would have to wait for care if we had to phone out to the compounding pharmacy. I think it'd be such a tragedy to postpone that care for that patient when we can safely compound the medications that we need for that patient. Number one, they probably wouldn't wait for us to do that, and because they're seeking some kind of care now, not a few hours later, not a few days later, in some cases probably a week later. So I'm supporting what these other doctors have said as far as the basically irrationality of this rule. Thank you.
Thank you, Madam Chair. Again, my name is Dr. J.C. Moore. I take issue with a number of parts of this proposed rule change, specifically 16.4.15.8A regarding the preparation of injectable medication. This is a rule that will require a level of scrutiny to advanced practice certified chiropractic physicians that no other healthcare provider is subject to. To better understand the impetus for this rule, I submitted a inspection of public records request to the Regulation and Licensing Department. Part of that request, I obtained or reviewed a document titled Analysis of 16.4.15 Chiropractic Advanced Practice Certification Registry Proposed Rule Changes. In this document, the board, the author of the document made the argument in favor of these rules proposed. Specifically for this item, it was stated, this is added to protect public/patients from improperly compounded injections compounded in a doctor's office who may not have sufficient experience or may not have sanitary environment in which to do the compounding. End quote. This reasoning is against the clear, weighted, substantial evidence of the record. In the 10 years that advanced chiropractic, certified chiropractic physicians have been performing their procedures, there has been one reported adverse event. That track record of safety outperforms any other provider group. The board is simply attempting to solve a problem that does not exist. Additionally, to try to understand more fully what other institutions were consulted in the creation of this rule, I asked for any communication between the New Mexico Chiropractic Board, the New Mexico Medical Board, the New Mexico Board of Pharmacy, or the New Mexico Department of Health about the appropriateness or the need for this rule. According to my response from RLD, none of these conversations occurred and none of these institutions were questions or discussion was had about the appropriateness. This leads me to believe this rule was conjured by members of the Chiropractic Board due to their biases against the Chiropractic Advanced Practice Certification as a way to restrain their practice and amounts to an abuse of discretion. If this rule passes, it will result in legal action against the board seeking injunctive relief from this ill-conceived and unnecessary rule. Additionally, 16.4.15.11F, this proposed rule specifies injections are to be subcutaneous or intermuscular only. Again, back looking at the document that provided the analysis, the board's reasoning, this designation should have been shown in the formulary when it was first added. This reasoning is unfounded and not congruent with the original statute. The restrictive language is not present in HB 275, which established the APC registry, or HB 14 that further defined the creation and evolution of the APC formulary. The statute is meant to guide the rules and should not create contradictions. I included a copy of those pieces of legislation in my submitted public comment prior to this. This rule will restrict our practice that we have been performing safely and effectively for 10 years and limit our ability to treat certain conditions by injections.
I'm Dr. Stephen Perlstein. Excuse me. I practice in Santa Fe. For the record, I'm also the president of the Academy of Advanced Practice Chiropractic Medicine. For the record, I teach and have been doing for a number of years the Advanced Practice Certification Relicensing workshops, specifically the injection workshops. I have been trained by organizations such as Hackett Hemwall and the American Academy of Orthopedic Medicine. The attendees are all MDs and DOs, anesthesiologists, a variety of. I have also trained personally with Tom Raven, whose textbook on prolotherapy is second to none. So my training is a little bit above and beyond the training that advanced practice certified chiropractors have had and continue to have, and I bring that to the relicensing courses. So regarding the last rule, the 11F, to restrict what the advanced practice certified chiropractors have been trained in and that their statute and rules have allowed them, there's no basis. There's just absolutely no basis, which clearly shows the unfortunate bias in whoever created the rule and whoever wishes to support it. As far as the compounding issue, I have one more thing to add. I'll give you something from the field. I practice in Santa Fe. One of the ingredients that is in our statute is procaine. Procaine is a compounded substance. You have to have a compounding pharmacy make it. Not all compounding pharmacies make it. I have to go to Albuquerque to get procaine. So, and then the other ingredients, well, there's numerous ingredients that I use. For example, one of them is a homeopathic medicine, which I have. I would have to go to a compounding pharmacy, and like I said, there aren't that many that will do this. I would have to bring the homeopathic medicine and bring the multi-use vial of bottle of procaine and ask them to put it together. They're not going to do that because it's an open vial. They're also not going to make the procaine for me. So I would have to go down to Albuquerque. I have no idea if they would accept my homeopath, etc., etc. This is a huge logistical issue that is absolutely unnecessary and will put a burden on the chiropractors who use this. If this rule goes into effect, it will pretty much wipe out, almost, what we can do by injection. And I have no qualms about saying that I know that that's what's behind this. Okay? Talk about a safety issue. There is no safety issue. I'm sorry. The other rules that I have in question has to do with 15.8b1, about a national recognized credentialing agency approved by the board. I believe that a nationally recognized credentialing agency, by virtue of that national recognition, does not have to be approved by the board. It's already gone through a much higher approval process. So I am against that one. There is 15.8B2, approval of the 90 hours of education. That doesn't exist anymore because of the sunset of the 90 hours of education. So putting a rule in now about that the education has to be approved by the board, the education doesn't exist anymore. The other rule is 15.8F, Advanced Practice Certified License Reinstatement. There is a discorrelation between license reinstatement that's already in rule for regular chiropractors and advanced practice chiropractors, because the advanced chiropractors, if they want to reinstate a license, they not only have to do what the regular chiropractors have to do, but then $100 a month, a penalty, a fine up to $1,000. Why? Why? Yeah, I think we advanced practice chiropractors are kind of special, but not special in the way that we deserve an additional fine for reinstatement of license. There's nothing in the rule that gives you any reason as to why we are singled out for an additional fine. That rule needs to be scrapped. The last one is 15.8K, the informed consent form. There is nothing in the rules for a regular chiropractor to have to, by rule, have an informed consent form for regular chiropractic care. I'm sure that most of us chiropractors would say that's a very important thing, but I could find nothing in the rules for that. So why now suddenly we have a rule that the advanced practice chiropractors not only have to have an informed consent form, but have to have the patient sign it, give them a copy, keep it in the record for each time, I interpret it this way, each time an advanced practice certified chiropractic procedure, whatever it is, it could be a prescription for muscle relaxant, is given. That's the way the rule is read by me. If you're going to have an informed consent rule for advanced practice chiropractors, you better darn well have it for regular chiropractors. Or, just as the fact that there is no informed consent rule for regular chiropractors, advanced practice certified chiropractors don't need it. I want you to know we use it. We do it because we take what we do seriously. We, along with chiropractic, are doing injections and doing prescriptions, and that's darn serious work. And we take that very seriously. And I'm coming from someone who helped create the law, and I'm coming from someone who teaches advanced practice certified workshops and the training.
Dr. Perlstein, I hate to cut you off, but your 5 minutes are up.
I'm done. Thanks.
Thank you. All right. Do any of the board members have any questions?
We still have comments.
Oh, I'm sorry.
I would like to comment. I'm Brian Dickert, private practice in Corrales.
Could you speak up a little bit?
Yes. I would like to speak in support of 16.4.15.8A. I believe that the as written, it does respect the public, and in addition, I would like to point out that the trainings of other professions that give injections are much higher and than chiropractors in this state. And in the event that I would ever receive an injection, I personally would rather go to a vet because I know they've done it a lot more and get more training in that. And that is it.
I have a question for the doctor. Would you rather go to a vet as in a veterinarian or a vet?
Personally, I would, because I understand they have more training.
Thank you for your comment.
Come over to the right. So my neck and my left for I'm Blair Alexander, chiropractor.
Blair Alexander.
I'm also an advanced practice chiropractor. I'm an orthopedist, board certified chiropractic orthopedist, and a fellow for the International Chiropractic College. I practiced in 45 countries through Missions Work, Samaritan's Purse, Red Cross.
I'm sorry, can you speak a
Through
little
Samaritan's
louder?
Purse and Red Cross and Wycliffe. This is more about just actually relational. This is about the compounding rule. I work primarily in my practice with medical physicians in the city of Albuquerque. Not through any particular plan, but quite a few of them are Presbyterian. As a matter of fact, we see each other quite often. And I did discuss some of the rules that, specifically this one. And my friends, who are physicians that have been practicing for many years, from a fiduciary standpoint, and I say that respectively for the patient. First of all, the chiropractic profession, from a time standpoint, can administer injections quite readily with our schedules, because the advanced practitioners right now are seeing patients, and I don't want to get into fee structures and those things, we don't do that here. But they can see patients readily, and the physicians of medicine are very, I mean, if I have to have evidence these conversations, I could provide them, are very excited about that. These are primary care blue-collar doctors in the city of Albuquerque, and I can name many of them that many of you may know. And they said, who wrote this rule? Because we don't do that. We never would have to do that. First of all, I would say this. If the medical physicians who would like to readily get these services covered anyway, but that's besides the point in their plans, they do refer to many of the chiropractic physicians. And it would slow down the administration of the procedure. It would, if we had to compound. And what that would do is, it does not protect the public. It doesn't do that. These folks have been waiting. They're in pain. And the chiropractor that has the advanced practice degree, like I do, but I don't do, I refer quite a bit of that out to my colleagues, because I'm very busy with, in a very, I guess we say, straight chiropractic practice, more manipulation. But I do see the benefits for this type of treatment. And the compounding, it's just, the rule just does not make sense. And from another standpoint, the medical physicians see that there are so many waiting lists for pain management in the medical realm. Some of my allopathic friends that have practices in pain management have waiting lists of 1 to 2 months. And chiropractic advanced practice physicians can readily see these patients. And my medical friend, not just 4, but like 32 allopathic physicians, and I guess since I'm stating this, I would have to probably get conversations or proof of it if you really need it. But we've talked about it for quite a while. Quite honestly, board, they would be referring over and have no problem with it. As a matter of fact, a few of the physicians need it done and want it done. But what I'm saying is it is a cost savings too. And I hate to just bring that up, but wow, my medical physician friends, they want to know about that. You know why? Because they want their patients to save the cost if it's not a provided or covered by the plan, which hopefully it will be soon. And I wanted to say that because after all, I've treated in jungles, and if I had to get, if I had to look for this type of rule in a jungle, taking care of folks in Indonesia, whether it be Bali or the Solomon Islands, I probably would be thinking sideways, because I've been trained to do this and I need to administer it to my patient. They need it. This is really about people. And yes, the advanced practice community is excellent at what they do. I've been a part of it and I've witnessed it more than I've probably practiced it in the advanced practice realm, but I am an orthopedist. And I am a chiropractor, and I'm saying, wow, these guys are really something, these physicians are. And I thank you guys. I really do. I thank the board for allowing me to speak. So that is my, my public comment. Thank you.
Dr. Michael Pridham, and I agree with Dr. Pugh, Dr. Raz, Dr. Ryerson, Dr. Pearlstein, Dr. Moore, And I'd like the record to show that the board chair removed the one advanced practice chiropractor on the board from this rules committee that was coming up with the recommendations. And it would seem like you would want to have the one expert in the field on that giving you recommendations.
Anybody else?
I'm Dr. Christina Lujan. I'm a practicing chiropractor in Albuquerque in sports medicine. I am commenting on section 16.4.15.9 on the registration and board requirements. I'm not a PDC. When I graduated, the rules have been changed, so we have to require a master's degree. From being in the practice now for 5 years, I see the value of an advanced practice doctor in the field and working with the other medical providers. I had to go on with my advanced practice through sports medicine and work on my diploma through that. Because I want to do advanced practice in the realm, I have to wait until the rules are changed, and until that happens, I can't do injections, which I refer out to my colleagues. But the value that the advanced practice brings to our profession nourishes our natural roots of chiropractic medicine, and it helps us flourish our heritage and our roots, so we could grow with modern medicine, and so we are not rooted out.
Thank you. Anybody else? All right. Do the board members have any questions for any of the presenters? None? I have a few. And for the sake of time, I'm going to just pick Dr. Pearlstein to answer these questions. I think everybody else would trust his answers. So, my first question is, how many hours of pharmacology do we receive in chiropractic college? Or did you receive in chiropractic college? How about we put it that way?
I'm Dr. Steve Pearlstein. I went to chiropractic college in the 70s. I do not remember how many hours I received. Christina knows? Do you know?
We were taught with the pharmaceuticals.
Say it that way.
We were taught by the pharmacy, and so our practice is more than what you guys got and we were tested on in the national boards in all 4 parts.
And what
So
college did you go to?
Texas Chiropractic College,
Okay.
and they are part of the advanced practice chiropractic, and they support it.
Is there anybody in the room that graduated, say, from Palmer, Life, Sherman?
Graduated from Palmer.
Do you remember how many hours of pharmacology you received?
I know between pharmacology and toxicology, it was at least 30 hours
3
per
hours?
semester, so it'd have to be 60 at least. It was 2 years. Excuse me, 2 semesters.
Okay. Back to Dr. Pearlstein, just because it's easier to stick with one doc.
May I add something, Madam Chair, I'm sorry? I graduated in 1991.
How many hours of injection procedures and compounding did you receive in chiropractic college?
Madam Chair, that is, we did not, and that is an irrelevant question completely.
It's relevant to me, thank you. How many hours of hands-on experience with injection procedures and compounding did the doctors receive in the 90-hour course?
How many hours? I think there were about 30 to 50. I'm not sure. The entire program. Does anybody know? Do you remember?
What was it?
We're talking about hands-on. Hands-on. That was actually 2 weekends, so
At least.
at least 30 to 40 hours. That's my guess. Yeah.
2 weekends?
Yes.
Your weekend courses were 10 hours apiece, right?
I think they were 12 and a half or 13, so that it comes up to about 25 hours.
So, Dr. Pendleton, when I asked you that question in a meeting, you told me 5.
Five
So
what?
we've got a big spread here, 5 hours. Within the 90 hours, there were about 5 hours of injection procedures and compounding information. Practical. So
I
we're
don't
somewhere
remember that.
between 5 and 25.
I would say about 25.
It was 25 or 12 and a half hours.
Mhm.
Okay.
There were 2 weekends, there were 25.
Right.
Were there any clinical rotations as part of the 90-hour course?
No, there were no clinical rotations.
All right. How many, this is for all of the APC doctors, how many of you have taken other training in compounding and injection procedures from entities other than the NMCA injection seminar?
Madam Chair, I'm Dr. J.C. Moore. I've taken Chiropractic injection seminars through UNM School of Medicine. Thanks.
Okay. How many hands were up? I missed it. 1, 2, 3, 4, 5? 6. All right.
Madam Chair, could you repeat that question just so I'm clear?
How many APCs have taken other training in compounding and injection procedures from entities other than the NMCA injection seminar? Okay.
I don't, Madam Chair, I don't have an exact number, but I do know that there are others who are not here who have taken it, especially the courses I have because they've been with me, but they're not here.
How many APCs here do not do injections at all? Do we have any APCs here that do not do injections that can? 1. Okay. How many of you all that do injections inject maybe a few times a month? Okay. How many a few times a week? Oh, y'all. How many at least on a daily basis? How many of you have had your office inspected by any entity in the last 2 years to look at your compounding area?
Dr. Michael Pridham. I reached out to Holly from the Department of Health about 2 years ago when she first recommended coming by and did not hear from her. And I responded a couple times and just, I was trying to set up a time for all of the chiropractors that wanted to come over and do it at my office and didn't receive a call back.
Okay, I appreciate that.
Madam Chair, Dr. Ryan Rouse, we put an official application in to the New Mexico Department of Health for them to come do a site inspection, and no response. I don't know if they ever leave the central corridor to do inspections, but maybe it's too far to travel to Farmington for them.
Madam Chair, I have a comment. This would be an appropriate question to ask for any other profession, including medical, osteopathic, nursing, if they've had the Department of Health come out and inspect their facility in private practice. Have you asked that question?
Of whom?
Any other profession that does injections, the medical profession? Osteopathic, nursing, dental?
Ask those professionals?
Yes, ma'am, that's my question.
No, I have no regulatory authority over them. Why would I be asking them those questions?
I think it's a legitimate question.
My concern is about our chiropractors, our APC docs, and that's where we're going with this, okay? So
Madam Chair,
my
can I comment on this question?
My last question is, how many of you are confident you would pass an inspection requiring the USP 797 standards, or even 795?
You're asking for in here, in
Yes.
this room.
Yes, the APC docs in here who do injections and compound in their office. How many of you are confident that you would pass an inspection?
Madam Chair, Dr. Moore, J.C. Moore, I've seen that statute and I'm curious what specific provisions you're referring to. It's a very, thousands of page document. Which provisions specifically are you concerned about us being able to satisfy?
Whatever ones that you are required to abide by.
there's,
Do you know
again,
what
the
they
document is
are?
thousands of pages, so you're being very vague. These provisions are for a number of institutions, including things that are outside of our scope of practice, including preparing IVs for chemotherapy and other things in a hospital setting. Of course, I could not, my office is not equipped to satisfy the needs on the same standard as a hospital.
More specifically, the low-risk compounding. 1, 2, 3, 4. Okay. All right. Those are my questions. Thank you very much. I appreciate your cooperation on that. Are there any other questions from the board? Are there any questions from the public to any one of the presenters? Go ahead.
Questions from the public to board?
To the other presenters.
I have a question for Dr. Perlstein. Have you been made aware by any board member of a barrage of complaints to the board about the dangers and injuries caused by your students, the advanced practice chiropractors?
I have not heard, Dr. Perlstein, I have not heard anything about any complaints, any dangers.
Is it your understanding that there still is just a single adverse event in the 11 years that over 100 of us have been practicing advanced practice techniques?
Yes, in fact, I spoke with the, I don't remember her name, doctor or something from the Department of Health. I spoke with her after she gave the presentation earlier this year, I believe, and asked her for more details. And she reminded me that any kind of, she wanted us to know that this had happened. She did not name names. And she also told me that we had a remarkable track record and that anything the Department of Health has suggested that we do regarding compounding and safety is a mere suggestion and not a requirement from the Department of Health. If it was a requirement, it would be a law or rule, and it is not. So, two things. It's not a requirement, it's a suggestion, and our track record, as she stated, is remarkable. And the one incident had nothing to do with compounding.
Thank you, Dr. First.
Yes, Madam Chair, my name is J.D. Bullington, and I'm going to ask a question just as a member of the public. I occasionally go to chiropractors, and I am curious to know what agents are being, and any one of you can answer this, what agents are being compounded? And is it a finite list, or is it a completely open list? And is it something you can make up as you go? I'd like to know more about what's being compounded and the process that follows.
I can answer that, if I may. Dr. Perlstein again. So, the substances that are in our formulary they're finite but not quite. What I mean by not quite is, it says all homeopathics. So I deal with two companies that make homeopathic injectables. One is called Medinatura, it used to be known as Heal, and also Heal. And also, I forgot the name of the company. Hebert, yes, Hebert, up in Boulder. And there are other companies. So the fact that we can do all homeopathics, that means that whatever a company legitimately makes, they may make new homeopathic injectables. So that's where the somewhat finite. But if we just call homeopathics finite, yes, it is a finite amount of substances. We're talking about homeopathics. We're talking about procaine. We're talking about Serapin. We're talking about saline and sterile water. We're talking about, I said Serapin.
Caffeine.
Caffeine, yeah, I don't know the formulary by heart. Michael, you do.
Mr. Bullington, may I speak? Madam Chair? Letter F.
Oh, right.
If you look at that, then you have it all in writing. under 16.4.15.11, letter F.
I just want to complete my answer to Mr. Bullington, and this is relevant to the rules hearing. We're all trained to know what to use for what condition, and we have variations on that. So there are some of us who just use a single substance, and many of us compound and put additional substances. And over 11 years, a lot of us have become quite well versed in what works best for what condition. But it is finite. We only use those and nothing more. Does that answer your question? I'm curious. Does that answer your question?
Yes, may I ask a follow-up question? So this is my last question. So thank you for pointing out the formulary. So I'm just curious, so can you compound in any ratio that you want a combination of testosterone, naproxen, ibuprofen, caffeine, and epinephrine? Could you do that?
To answer your question, that would be completely irrelevant. It's like if you take a medical doctor, they have full license, power, and authority, but they're trained to know what to use, what to compound. We are also. I know there's a prevailing opinion amongst people who don't care for what we legislated, that we don't know what the heck we're doing. Well, we do. So we compound appropriately. I compound a homeopathic with procaine. I might have Serapin involved in that, or not. It's my expertise in what I've been trained in. And to compare it to regular chiropractic, we're experts in adjustment, we have our way of adjusting. And we use whatever techniques we feel are appropriate. Where did we get that training? In school. And the same with us. We got very high level, appropriate training to be able to do what we do. It's so foreign from adjustments, but we got the best training. And now, because of the coursework that I've taken and Dr. Jones has taken, and we're doing the workshops for continuing education, we bring this additional knowledge to the advanced practice chiropractors. So we, at this point, after 10 years, are more highly trained than when we started. And that's a plus. So we know what we're doing, just like everybody else does.
Madam Chair, may I please comment to Mr. Bullington's question?
Yes.
Again, J.C. Moore. Mr. Bullington, the items that you listed specifically are not available to us by injection. Those are oral administration, topical administration, so we wouldn't be drawing up testosterone for injection. We wouldn't be drawing up naproxen, ketoprofen for injection.
Thank you.
Thank you.
I have another question for Dr. Pearlstein. And I don't know if you're the one that could answer this, or perhaps the executive director for the association, but in the last 2 or 3 years, how many attendees have you had at your injection seminars?
Oh, do you know those numbers?
Well, in February.
Say your name, please.
I'm sorry. Diana Statsula, Executive Director with the NMCA. And we had in February 60 advanced practice chiropractors. But I cannot refer to last year because I was not involved at that time.
Do you know if, because I know it was advertised that it might be the start of a new program, so, excuse me, DCs that might be interested in getting an APC license or certification could attend that particular seminar. Do you know if everybody attending were APCs, or were there some DCs in attendance?
There were a handful of DCs in attendance that were not advanced practice.
Okay. So I was in attendance at the seminar the year before, and I believe there were like 45, 47, something like that. Dr. Pearlstein, does it give you any pause at all that we have APC doctors properly certified that don't give any injections, haven't given any injections in the last 5 to 10 years, obviously are not attending at least the association's injection seminar because we have 125 certified APCs. That we have APCs out there that aren't regularly giving injections aren't regularly attending injection seminars, but they're fully certified, so they could decide, you know, a week from now that they're going to compound and inject in their office. I think this is where our biggest issue is that we know that there's a segment of you all that are well-trained, and we're not worried about you. What we're concerned about are the ones who, you know, have their certification, but have not been involved in compounding or injecting for years, and yet tomorrow they could pick up a syringe and proceed. And so, you know, this is a lot of the background to it. It's not a matter of trying to restrain your trade. It's a matter of how do we look out for the safety of patients when we have this diverse, you know, set of APC doctors.
I'm a little confused by the question because, to the best of my knowledge, if an advanced practice certified chiropractor does not relicense, does not take the trainings and the workshops, then they lose their ability. They're done. They're not APCs anymore. That's as I understand it.
Well, there have been CE seminars approved over the years. In the last couple of years, I've tightened it up and insisted that CE for the APCs, you know, meet the requirements, which is pharmacology, toxicology, pharmacognosy, and the procedures that you all use. But prior to that, that wasn't necessarily required. So, you know, we know that there are APC docs out there that aren't trained up to the level that you all are. And we're struggling with how to deal with that. And if you've got some suggestions, we're open to suggestions. This was our way of trying to deal with that. And obviously it's upset a lot of people. We will be looking at your comments very closely and at comments that our leadership at RLD have made to us when we make our decision. But that's some background on why we proposed what we did. And I'm just wondering if you have any pause at all about, you know, the fact that there are APC docs out there that perhaps are not up to snuff.
I appreciate that. I've noticed over the last few years, I guess, that you've wanted APC doctors to attend an injection workshop. And I am completely in favor of that for all the right reasons, for all the reasons that you want. Now, if you're talking about the ones who sort of have escaped that, who have just taken non, we've had injection workshops, maybe not every year, but almost every year since 2009. So I'm not clear how many have escaped that and still have been able to keep their license. I would imagine it's very few, because after a while you've got to attend an injection workshop. How else are you going to continue your APC? And to the best of my knowledge, there's a lot of APCs who have dropped out and who have given up their APC certification. And for those, as I understand it, it's because there were a lot of chiropractors who really wanted to get this certification to do IV treatment. And we didn't get that. So they dropped out. That's maybe helps understand why some are not doing it. I don't know how, I was told there maybe are 50 or 60 or 70 APCs that are actually certified and up to date, and not the 150 that there used to be. You know?
Our latest count is 125.
Well, I just don't see how many of them could have missed an injection workshop. I don't know. JC?
Dr. JC Moore, again, your concern is invalid here, and the way that you're trying to attack your concern there is not valid. The board has a mechanism to address that concern right there. You can require specific CE use credits. So if you're concerned about injection therapy, then you say every APC must take 10 hours this year in injection. Secondly, the whole standard is just, it's preposterous. No other medical profession is subject to this. A podiatrist has the ability within their scope. There's nothing that limits them from treating a neck. There's nothing that limits them that says they can't treat a low back. but they don't because their specialty is a foot. So if a chiropractic physician, an advanced chiropractic physician, wants to use their advanced practice licensure to do only hormone consultations, or maybe they like it because they can prescribe topical analgesics to their patients that are in pain, and they don't have any desire to do injections, it's on the purview of the provider to provide something that they feel is appropriate and within their abilities. And again, I go back to the fact that we've had one reported incident from this. Those chiropractors are doing it. So it's not like these advanced practice chiropractors that you're concerned about that aren't taking these injection seminars are out there injecting people unsafely and creating this public health risk. It just doesn't exist. And you have a mechanism within the current rules to address your concern about patients or APCs not having injection-specific coursework. Thank you.
And I'm, excuse me, Blair Alexander, I'm one of the APCs that doesn't do any of the injections. So I feel like I'd like to at least comment in a very, very, very just cool way here. I know it's so cool. But here's the thing. I go to the injection seminars every year. I go to at least one. And I sit down with my colleagues, we were just talking about it before the meeting, because you know what? I can do the injections, but I treat, okay, it's on the subject. I treat osteopaths in my office all the time. Their comment is, I wouldn't send this over, I wouldn't treat it, so that's why I send this kind of stuff to you, just Blair. It's not that they can't do it, they feel more comfortable. That's a clinical decision for my osteopathic buddies and MD buddies, because they could do it too, but they don't want that manipulation. But, you know, the osteopaths feel comfortable with it. It's their discretion. My discretion is to do it at the seminars. I can do it, and I don't think I'm as proficient as far as being the top shelf as some of my colleague friends here are, because I have some fabulous ones that are right here, and I'm not blowing air up their skirts, but they're great guys, and they're great physicians. But for me, I feel more comfortable with it, but I do go to those seminars, and I do learn things, but I'm comfortable where I'm at in my practice right now. And that's on me just being honest with you guys.
I want to make one more comment. I want to make an analogy to the general chiropractic profession. I think we all know that there are chiropractors who adjust a lot and chiropractors who don't. Chiropractors who are more into nutrition, and the adjustment is somewhat secondary to them. I've met many of them. I've met many chiropractors who I've experienced are not good adjusters, in my opinion. So when we relicense, we don't always have adjusting seminars. You would think, to make an analogy, you would think that every year there should be adjusting seminars so that we could be better at adjusting. But that's not necessarily the way we do it. Our thoughts are we're trained in adjusting, we practice as we go along, and we get better and better and better. So, but I can understand, because injection work is so different than chiropractic work. But you want to know something? It's not any more dangerous. We just take chiropractic adjustments for granted, if you will, and we're very good at it. But yes, I agree that every year there should be an injection training workshop, and I know that puts the burden on me and Dr. Jones. Every year we have to do this, and I would love for other people to do it. We want to get better and better and better at injecting. But also notice you want to get better and better and better at chiropractic adjustments, but the board does not see fit to make sure that there are chiropractic adjustment seminars as part of the convention, so to speak. And then also, nobody has to go to the convention. If there were chiropractic adjustments seminars at the convention, you'd have to, by rule, say you have to go, and if it's outside, you have to get chiropractic adjustments outside of the convention. So I'm just pointing out the discrepancy there. I agree with you that the injection seminar should be every year. But there are those like Dr. Alexander who don't do any. Your concern is that one day he's going to say, I want to do injections, and he's not going to be well versed. But he does attend the injection seminars where he does injections. There aren't any newbies anymore at the injection seminars, but there are people who don't inject much. And I purposely go to them and spend time with them. to make sure that they're good at it. But really, it's the same analogy between that and chiropractic adjustments.
So one quick question, and then we're going to move on, okay? Do you, in your injection seminars, require each attendee to garb up, glove up, and show you that they can do compounding and that they can do injections? Or are some of them who just really don't want to do it allowed to just watch?
Well, it's a good question. And the reality of it is there are always a few who try to just kind of work around the edges. They observe, but they don't want to be injected. They don't want to inject. I encourage them to do it, but I can't force them. In the same way that if you have and we did a couple of years back, we had adjusting seminar. And there was no requirement that everybody adjust, but everybody did. So I hear your concern, but I don't think that you could have a rule that said everybody attending an injection seminar has to do it, just like you can't have a rule that says everybody attend an adjusting seminar has to adjust. You better sign off here, we better videotape that you're doing it. So it's a gnarly kind of question. I hope that helps.
Thank you, Dr. Pearlstein.
You're welcome.
We're going to move
30
on.
seconds.
We've put a lot of time into this, and we appreciate all the comments, but we do need to move on at this point. So we're going to move on to Title 16, Chapter 4, Part 16, Parental Responsibility Act Compliance. Do we have any comments from the public concerning this part? No comments, so we will move on to Title 16, Chapter 4, Part 17, Supervision of Interns. Do we have any comments from the public concerning this particular part? All right, none. So we will move on to Title 16, Chapter 4, Part 18, Practice Procedures. Do we have any comments from the public concerning any changes in this particular part? No comment? Okay, we will move on to Chapter 4, Part 19, Chiropractic Assistance. Is there any public comment from anyone about Part 19? All right, moving on. Title 16, Chapter 4, Part 20, Advertising. Are there any public comments to Part 20? No. Okay. We will move on to Title 16, Chapter 4, Part 22, which is fees. Are there any comments to Part 22? No. All right. We will move on to Title 16, Chapter 4, Part 23. Are there any comments from the public concerning Part 22? No. So we have heard all the proposed rules. I've received testimony. We've had questions and discussion. And this hearing is now brought to a close.
It will be entered as number 45, exhibit number 47.
Thank you, Mr. Alderete. Do the board members have any questions about the attendance sheet? Exhibit 45. Being none, Exhibit 45 is hereby admitted into the record. The comments submitted and the discussions heard during the rule hearing will be considered and may be discussed further by the board when it holds its meeting immediately following this rule hearing. Other than lunch. Do we need to act on that? Okay, we may break for lunch. The board will vote on the proposed rules at that time. Any rules adopted by the board will be filed at state records and archives in accordance with the State Rules Act and the New Mexico Register publication deadlines. The adopted rules become effective 30 days after they are filed at records and archives, unless otherwise noted at the end of a section. I would like to thank all board members and everyone else present for their participation and attendance today. Let the record show that this hearing was adjourned at 7:52. Be dealt with again. Place it before 3, approval of minutes. If everybody's okay with that, somebody give me a motion. That way, we can get the court reporter on her way. So, do I have a motion to amend the agenda to move new business A to just before approval of minutes?
I make a motion to do just what Kathy said.
Do I have a second?
I'll second it.
Okay, any discussion? All in favor?
Aye.
Any opposed? All right, that's what we will do. We have approved the agenda, so we will move on to new business. A, consideration of adoption of the proposed rules. And we will basically do as we did before. We'll start with part 1 and go forward from that point.
Madam Chair, I do have a question.
Yes.
Dr. Pendleton. When will you be discussing again this letter that's been written, given to us by our Director of Boards and Commissions?
That will come up during the discussion of part 15.
Part 3, I'm sorry. So there's 2
Oh.
comments.
Are you concerned about the other 2 comments, or just the comment about?
Well, I just want to know when she's going to, is she going to present this as to the board and to the public in person? Or are we going to read this to the public?
We will read it.
Madam Chair, members of the board, in response to your question, Dr. Pendleton, so the letter that you're referring to that came from RLD is part of for the rule hearing. That has been included as an exhibit in the rule hearing packet. So certain parts that will be discussed from this memorandum that as they correspond to the rules as we go through them. So the first comment on this page is for 16.4.3, or the first 2 comments are for that rule. We'll discuss, the board can discuss those 2 comments when it's presented, when the proposed rule is presented, and then the same going forward.
Okay, thank you.
Okay, so yeah, if they have comments about a certain part, we'll address it at that time. All right, so we will start, and we will go to 16.4, part 1. There are numerous corrections in here as far as corrections in spelling. The main one is correcting the board's name to New Mexico Chiropractic Board. It's mostly housekeeping. Do the board members, let's see, I need to take a motion, right? And a second first, and then we discuss? Yeah. Okay, I need a motion to accept the changes in Chapter 4, Part 1.
I make a motion to accept the changes as they are in Chapter 4, Part 1.
All right, do I have a second?
And I'll second it.
All right, any discussion? All those in favor?
Aye.
Any opposed? Going on to Chapter 4, Part 2. Again, this is housekeeping mostly, correcting misspellings, and correcting the name of the board to New Mexico Chiropractic Board. Do I hear a motion?
I make a motion to accept the changes of Chapter 4, Part 2 as they are written.
Do I hear a second?
I'll second it.
Okay. Any questions or discussion? All those in favor?
Aye.
Any opposed? Okay. I don't think I can remember that per word, but we'll go for it. All right. Next is Chapter 4, Part 3, Requirements for Licensure. This one has housekeeping and an additional rule. And we oh, okay, yes. We do have a comment. It was entered, this document was entered into exhibit. It's comments from RLD. And we do have a comment on 16.4.3.3. It's more housekeeping. Shall I read it? Okay. Reference to section 61-4-3. Point G of the Chiropractic Physician Practice Act should be corrected to reference section 61-4-3G to be consistent with other statutory references in the proposed amended rules. All right, so, consider that comment is mostly housekeeping. Do we have any do I have a motion on this particular part?
On that one comment, on that one change?
No, on the entire part.
Should read that.
That's not on 3, that's on,
Oh,
yeah. There is
no, it is part
It is part 3.
Oh, 3.9, okay, I'm sorry. Yes, 3.9, we have a comment based, or from RLD on that one. It's the, what we titled New License Presentment to the Board. Comment from RLD is that the new requirement in 16.4.3.9A and MAC cited below applies only to new licensees after January 1, 2019, and may be perceived as arbitrary. This new requirement may place an economic hardship on a new licensee that does not apply to current licensees. There may be a less burdensome means for the board to meet the stated goal of instructing new licensees regarding the regulations under which they may practice and on the role of the board. Should we handle each section separately? And should we handle the motion on this particular proposed rule?
I'm sorry, do we want this on the record? I can't hear you. Oh, Madam Chair, members of the board, I think what would be in the best interest of the board at this time is just to have the board have any discussions specifically on this new portion of the rule at 16.4.3.98.
We don't need a motion?
No motion. The motion will come after the
Okay.
discussion for the board to determine whether or not they want to incorporate the comments into the rule as proposed.
Madam Chair, I have a comment.
Yes, sir.
I propose that we amend 16.4.3.9 to add in, within 1 year from the date of the issuance of the initial license to practice in New Mexico, every new licensee is required to present themselves in person or live internet feed to the board at a regularly scheduled board meeting, period. And then the rest of the paragraph would be the same.
The question would be, do we have the equipment to do that, to teleconference?
We don't. Not to do that. We don't have the time either.
50th again.
I'm not a real fan of this particular proposed rule, and apparently neither is RLD. And I understand why. And so I think we need to take that into consideration. Was yours presented as a motion, Dr. Pendleton? Or was it just a comment?
There's a comment, and the RLD does say that there may be a less burdensome means for the board to meet this stated goal. So,
Yeah, but if
we're not saying not to do it.
teleconferencing, if teleconferencing is what your suggested less burdensome approach is,
Do you guys have a
we don't
suggestion?
have the equipment to do so.
Could I ask somebody from the board administrator's point of view, do you have a suggestion?
I do not have a suggestion.
So, Madam Chair, the idea when we did this was that we felt like that the Board of Examiners should have the ability to see the people that are coming into the state and talk to them, like they did you, absolutely, they did me. And I've been one of the sticklers, and I like to see people that come and let them know we appreciate them coming to Mexico. We have people here we care about, and we want them to make sure that they keep a high quality and a high standard like they are now out of college, and just give them a goal to be the best physician that they can be, the best chiropractor that we can have, and to keep New Mexico safe. So that's the reason I felt like we missed it by not having people come in and get to know them. Some of the people that are in here, I've never seen them. And I feel badly about being on a board for you that you've never seen me. I've never seen you.
Madam Chair, members of the board, the only other suggestion that I could think of is maybe you create a committee, maybe some kind of an application committee where whoever's on that committee would be willing to meet with them via internet, face-to-face, or through the internet. Maybe they have some kind of a system that they can use, maybe FaceTime or something like that.
Well, we have a licensing committee.
Is that something?
Can we give them, can we come up with a policy or rule that gives the licensing committee the authority or opportunity to do that?
I think we can scrap it. I just felt strongly that we need to get to know each other. We can do that at a convention.
I think it's a
Two
great
separate
idea, but
associations?
it's not very workable. It puts a whole nother burden on top of our staff that they have enough on their plate as it is. That's my opinion.
Well, Wayne Goforth thinks that it won't make a worse chiropractor if we don't need him. I think they'll still be just as good a doctor without knowing who we are. So I can do without this.
Madam Chair, members of the board, I know that they're, like Dr. Goforth and Dr. Pendleton, they have been strong proponents of adding this new rule to the Board of Chiropractic Examiners rules and regulations, but it's here. And if they feel strongly that maybe it should be in there or whatever, one of the things that I would suggest is including language that says something like that there is a sentence in there that says the board may extend the one-year presentment requirement upon request by the licensee in a showing of good cause. Maybe adding something to that sentence that the board will also consider a request by a new licensee or may also waive this requirement for the new licensee if circumstances exist that prevent them from coming in and meeting with the board. That might mean something else for those who are interested.
Who decides what that hardship is, or, who would make that decision?
It would be up to the board, I think.
Madam Chair, members of the board, I was thinking about this and I actually suggested this in the Rules Committee, is if the main point is to tell the new chiropractor that we want them to do the best job, that we have a complaint process, that there's these members of the board and we meet this many times a year. If that's the main point of this, then I think we can handle this with a letter that acceptance, when we issue a new license, we can send a letter saying that what we expect from them, where they can find the rules, where they can find the complaint procedures, and things like that. That way we can say that we've informed the new chiropractor of who we are as a board, what we do, and how we want them to act professionally and so on.
That could just be like a policy statement.
Right, I don't think that would require a rule change, it would just be something in-house that we would come up with a template letter and it would get issued with the license and sent with the license, when every new license issue.
Could the board include in the language of that letter that if a licensee wishes to attend the meeting, the meetings are open to the public, and of course, and they can call. That way, I think it incorporates Dr. Pendleton and Dr. Goforth's intentions. And if new licensees want to come and see how board meetings are conducted, they have that open invitation to do so.
Sounds good.
Okay, so does somebody want to make a motion?
So are we making a motion to scratch that paragraph?
16.4.3.9.
Are you making that motion, Brian?
I'll make a motion to accept, what chapter is this?
16.4.3.9.
Yeah, well.
16.4.3.
To accept chapter 4, part 3 as is, with the exception of scratching the paragraph 16.4.3.9.
Excuse me, I can't hear you.
I'm sorry, what would be the proper language to not adopt the proposed rule as opposed to scratching it or scrapping it?
I think it would just be a motion to accept the proposed rule, eliminating 16.4.3.9.
I make that motion.
Madam Chair, members of the board, Lila, would we still be able to adopt the rule?
Yeah, motion to adopt the rule with the elimination of.
So because that's like a major change, so we would still be able to do it, it wouldn't have to go back to, we wouldn't have to table it, it's not a question. Okay.
Basically, we're making a motion to accept the proposed rules changes in 16.4.3, except eliminating 16.4.1 with the elimination. Okay, do we have a second?
I'll second it.
Any further discussion? All right, all in favor?
Aye.
Any opposed?
Nay.
Who said?
Dr. Hamilton. Okay. Moving on to chapter 4, part 4, licensure without examination. Do I have a motion to accept as presented?
I make a motion to accept chapter 4, part 4 as it is written.
I'll second it.
Any further discussion? All in favor? Any opposed? Chapter 4, part 5, criteria for determination of equivalency in the Council of Chiropractic Education. This is all just housekeeping. Do I have a motion?
Make a motion to accept chapter 4, part 5 as it is written.
I second it.
All right, any further discussion? All in favor?
Aye.
Any opposed? Chapter 4, Part 5, criteria for determination of equivalency, Council of Chiropractic Education. The only change would be the name of the board. Do I hear a motion?
Question, I think
Yes?
that's part, we just did part 5.
Yes, do it. Oh.
So this would be
I
part
have
6.
duplicates of some of this, I'm sorry. Okay, Chapter 4, Part 6, chiropractic practitioners examinations. Two housekeeping changes. Do I hear a motion?
A motion to accept chapter 4, part 6, as it is written.
Second. Any discussion? All in favor?
Aye.
Chapter 4, Part 7. Again, housekeeping issues, change the name of the board, change the numbering, change some misspellings. Do I have a motion?
Madam Chair, it didn't change the numbers, it just made it so that it read properly, is that correct? We didn't do any changes, we just.
Well,
made
okay, yeah.
I make a motion to accept chapter 4, part 7, as it is written.
And I'll second.
Any further discussion? All in favor?
Aye.
All right. Chapter 4, Part 8, disciplinary proceedings. Again, housekeeping issues, correcting misspellings, changing the board name. Do I have a motion?
I have a motion to accept chapter 4, part 8, as it is written.
And I'll second it.
Any discussion? All in favor?
Aye.
Chapter 4, Part 9, license renewal procedures. Housekeeping, spelling, changing the board. Do I have a motion?
I have a motion to accept chapter 4, part 9, as written.
And I'll second it.
Second by Dr. Preston Chavez. Any further discussion? All those in favor?
Aye.
Any opposed? All right. There's a number of changes in part 4, or chapter 4, part 10. Shall we take them one at a time?
Yes.
All right. No.
I have comments for 16. I can't hear you.
So I need direction here. Do we, the question is, with each thing that we hit, that we change, do we discuss each one of them separately? Or do I ask board members for,
You discuss, you want to discuss the comments that were made for this particular regulation, both during the public comment period and the comments, if there were written comments submitted.
so I ask the board members if they want to discuss the comments from the public?
Not if they want to discuss, there needs to be a discussion about
Need
the
to
comments.
discuss, okay. Did everybody take good notes? Sure.
I think Dr. Moore said something about having to wait up to 90 days. Is that what you're talking about? To get credit because he used.
Yeah, his question was, would any new employees be added to help deal with the extra work that these changes might create? And he was concerned that it might take even longer to get approval. We've basically been handling the credit hours as contact 60-minute hours for quite some time. By correcting and changing some of the changes here, it will actually make it easier for us to approve seminars, because often we were getting questions about, because the way that the rules were set up, it was very confusing as to what might be automatic, what might not. The fact that even if they were automatic, they still had to meet the criteria and file a application. So we've basically been dealing with this all along. It was just a matter of getting it clearly stated in the rules how it would be handled, and in fact, changing the rule where we accept courses through the Federation of Chiropractic Licensing Board's PACE is going to speed things up, because if they're a PACE-approved course, we don't have to go through all of the application. So that's actually going to help speed things up, having that agreement with PACE. And the changes as far as excess continuing education hours is just, it doesn't really require any extra work that I can see for the staff. The change where a licensee between March 1 and June 30 of the renewal year is not required to submit continuing education. Just getting that in the rules helps them see that in the rules, so that they know that they aren't required to get CE if they fit in that category. So, in my opinion, basically we're doing all of this right now. It's a matter of getting it clearly stated in the rules, how it functions, how it works, and it's just a matter of being clear that that's how the process takes place. But, I don't know. Dr. Pendleton, you're the other one that deals with CE with me.
Yeah, to answer your question, Dr. Moore, if more entities would become PACE certified, it would make it extremely fast. As soon as we see PACE certified, it's automatically reviewed. So. Okay, Dr. Moore, have a question?
Any other discussion amongst the board members? No. Okay. So, do I have a motion?
I have a motion to approve chapter 4.10 as it is written.
And I second it.
Any further discussion amongst the board members? All those in favor?
Aye.
Any opposed? Okay. Okay, on to chapter 4, part 11, forfeiture of licensure, or license, housekeeping, change the name of the board, insert letter B. Do I have a motion?
I have a motion to accept chapter 4, part 11 as it is written.
And I'll second it.
Any further discussion? All those in favor?
Aye.
Any opposed? Chapter 4, Part 12, classification of chiropractic licensure. Again, we have housekeeping issues. Do I hear a motion?
Make a motion to accept chapter 4, part 12 as it is written.
And I'll second
Any further discussion? All those in favor?
it. Aye.
Aye.
Chapter 4, Part 13, reinstatement of chiropractic licensure. Again, housekeeping issues? Can I hear a motion?
Make a motion to accept chapter 4, part 13 as it is written.
And I'll second
Any further discussion? All those in favor?
it. Aye.
All right. Chapter 4, Part 14, Management of Medical Records. Housekeeping issues? Can I hear a motion?
Sorry, I'm just not quite clear.
Oh, okay.
So somebody else can make the motion.
I make a motion to accept chapter 4, part 14 as is.
I will second it.
Okay, any further discussion? All those in favor?
Aye.
Any opposed? All right. On to part 15. So do we, refer to each one, or do we refer to the different issues that were brought up? How do we proceed with our conversation?
Madam Chair, members of the board, I think what you should first consider is the memo from RLD regarding this part of the administrative code, and then move on to discuss any of the other issues that were brought up during the public comment period.
Okay. We have a comment on the document, comment 4, proposed amendment to 16.415.8A NMAC. The new requirement in the proposed amendment to 16.4.15.8A NMAC for a chiropractic physician to use compounded substances prepared by a certified licensed compounding pharmacy.
Madam Chair, you skipped comment 3. She's reading that one. Comment 3. It's part of 16.4.15.
Okay, I see what you're saying. Comment 3, correction to 16.4.15.3 NMAC. Reference to Chiropractic Examiners Practice Act should be corrected to be reference to Chiropractic Physician Practice Act, to be consistent with other statutory references in the proposed amended rules, and to conform to the proper enactment citation in the New Mexico statutes. Comment 4, proposed amendment 16.4.15.8A NMAC. The new requirement in the proposed amendment to 16.4.15.8A NMAC for a chiropractic physician to use compounded substances prepared by a certified licensed compounding pharmacy may be perceived as arbitrary and capricious and requires further review, study, and consideration. The boards and commissions staff recommends that the chiropractic board postpone this amendment until further review, study, and consideration may be sought between and amongst the chiropractic board, the pharmacy board, and the medical board to determine the best regulatory course to protect the health and well-being of New Mexico citizens regarding injections by certified advanced practice chiropractic physicians pursuant to NMSA 1978, sections 61-4-3, 61-4-9.1, 61-4-9.2, 61-6.5, and 61-11-6. And then the next comment is correction to 16.4.15.8B3 NMAC. Reference to NMSA 61-4-9.1 D2 should be referenced as section 61-4-9.1 D2 NMSA 1978 to be consistent with other statutory references in the proposed amended rules and to be consistent with requirement of the Administrative Law Division of the Commission on Public Records. So basically, comment 3 and comment 5 would be housekeeping. It's just a matter of getting the proper notations and that. Okay, so comment 4, I would strongly encourage the board members to consider, what the boards and commission staff is recommending. Do we need to discuss this first, or do we need a motion? How shall we proceed on this one?
You can proceed with discussion at this time, both on the comment and the comments that were raised during the public.
Okay, so on this comment and any other comments that were made?
Yes.
Okay. All right.
I suggest that, I mean, as far as discussion goes, if the recommendation is that we postpone so that we can get more information, I recommend that we postpone and get more information and make a decision on a later date.
So my question would be, what the proper, I mean, I've never postponed, I've tabled, but I've never used the terminology postponed. What, do we have someone here from boards and commissions so that we understand what they're meaning by postpone?
Let's say table.
Is that what they basically are referring to as tables?
Yes.
Okay. And based on our conversation that we had, correct me if I'm wrong, but if we table this, if we make a motion to table it, it would require that it would, without having a new rules hearing. It's not like we're tabling it to move on at another board meeting, correct?
Correct.
Okay. So just understanding that if you table it, we're tabling it, and we won't be bringing it up again unless there's another rules hearing somewhere along the line. If you were more interested in setting it aside to get more information, I don't know how we would.
Madam Chair, members of the board, you can always table it and then move it to a future rule hearing. You can have a rule hearing anytime.
Oh, yeah, but it takes like 2 years to get it to happen. I mean, honestly, by the time you go through, and 1 year you get the funding for it, and then you have to go through all the hoops to get it set up, it has taken us 2 years to get here. And I mean, I strongly heard the complaint about, correcting the problem with the APC doctors losing their certification if they didn't, renew their DC license on time. It's taken us 2 years to get here to fix that. And we've wanted to fix it for 2 years. We have been forced to abide by the rules as they were. And we didn't make those rules. They were there before any of us ended up on the board. But it's taken us 2 years to get there. So I'm just making sure the board members understand that tabling this means we probably won't deal with it again for 2 years.
So you're saying you're tabling the entire,
No, we would be tabling just the compounding,
Just this
the
part.
proposed compounding rule.
Madam
then
Chair.
why are you bringing up about renewals? That's something completely
No,
different.
I was just using that as an example of that it took 2 years to get here to even deal with that problem. So,
It won't.
just
take
saying.
2 years.
I haven't seen it in my experience on the
You
board,
guys
we
will
could have
have
a
a little
rules
bit of-
hearing every year.
Yeah. A lot of boards, we have some boards that will have 2 rule hearings in a year, but the norm is one has dental board.
Well, I think part of our problem was we couldn't get it funded. It wasn't being requested.
Or that's what you're being told.
That's being told.
Yeah, you guys have gone through some turnover, so
All right,
things have gotten
but
better.
I just wanted the board members to understand that if we table it, it doesn't get dealt with without having another rules hearing. Okay?
So read me the part that you're talking about.
I'm
It's
sorry,
the
say it again,
compound.
please. I didn't hear you, I'm sorry.
I said, read me the part that, on the compound.
The proposed rules change is for a chiropractic physician to use compounded substances prepared by a certified licensed compounding pharmacy. Okay? 16.4.15.8A. And it's, even though I see deficiencies and I have concerns, obviously there are big issues to jump over here. If there aren't compounding pharmacies in some cities, that's a big issue. If compounding pharmacies can't get these preparations to them in a timely manner, that's an issue. If it's going to cost a patient more because they have to come one time to get diagnosed and the doctor has to send the prescription into a compounding pharmacy and then they have to come back a second time, that's a second office visit. And so you're basically, what we're doing is weighing patient safety against cost-effective and timely pain management. And I hear what they're saying, you know. It's, on the other hand, we need to find some way to be sure that, you know, they're trained properly and that their offices are set up properly for compounding. And we're going to have to, in my opinion, revisit that.
Madam Chair, might I say that what's been presented here today makes me see in a different light that we're not having as much problem with the compounding as I thought we were because of the limited amount of compound you're using and the safety of it. And if that's the only problem with this particular area, can we strike that compounding unit, since it doesn't look to me like it's saving lives, and there doesn't seem to be a threat to the people that are getting injected, since it's muscular and subcutaneous, so we're not getting into arterial or any kind of old man lost his thought. So IVs, we're not getting into IV type situations, and so can we not just strike that part?
Well,
and
that's
keep the
what
rest
is
in?
being suggested, is that we set aside, table postpone that particular proposal.
No, I'm not suggesting we table, I was suggesting we strike that language out and keep the rest of it.
So, can I make it?
Well, I would like to table it so that we can continue to look into it, just because I still have the issue of those APCs who haven't been getting the injection training, and they're, you know.
This doesn't address that.
Madam Chair, members of the board, you know, what I want to remind the board of is, even though that this comment was submitted by RLD, there were other comments submitted by the audience during the public hearing that weren't necessarily about the compounding of substances, but also had to do with, I believe Ms. Lujan addressed issues with who would, changing requirements for AP certification so it could be more inclusive of new doctors of chiropractic that have graduated or recently graduated and would like to obtain that certification. There was also a comment about subsection F of this particular part and the renewal dates and the language contained in there. My recommendation and my advice to the board is to, at this point, table 16.4.15 so that you can go back and take into consideration all of the comments that were made to all the parts of this rule, and then bring the rule back for a rule hearing sometime in the future. It doesn't make sense, at least at this point in time, to strike certain language and keep other language in there when there have been comments about the rule in its entirety. So again, what I would recommend is tabling this rule for further consideration, so that the comments made by the public during the rule hearing and by RLD can be considered by the board and incorporated into a new rule. And at that time, we'll repeat the process for setting up a new rule hearing and establishing a new time for public comment. What I would also recommend, based on some of the things that were brought up at during the rule hearing, is that, and I know we've had this discussion before about the rules committee, but possibly including a doctor from the APC community on that committee to give more insight into, you know, what they do, as well as having meetings with the Board of Pharmacy and the Board of the Medical Board, and whoever else was mentioned in RLD's memo. That way, I think by establishing that kind of process, you include all of those members from the community, and at the same time, I think the board would be able to come up with a rule that incorporates all the views and would be less likely to be challenged, I think, in a public rule hearing. I could be wrong, but that would be my recommendation at this time.
Madam Chair, I suggest that anytime we get the chiropractic profession together and they all agree there's something wrong. Well, I think that's dreaming that we're going to get this ironed out. And there are only a couple of areas in this that are a problem, if I understand it. One of them is the compounding, and what was the other one?
A few things.
Well, here's the thing, if we just don't do the entire part, okay, that means that correcting the issue of the APCs losing their certification if they don't renew on time doesn't get fixed. And the other one that I'm concerned about is we're in a situation right now where it is not in the rules that the board approves the master's program. We have a master's program out there, we don't know what's in it. And I was advised by the AG's office a long time ago to get that fixed, that it should be in the rules. And so there's some things in here that really need to be taken care of. I'm perfectly fine striking, use your term, tabling the compounding proposal of the rule. But some of these others, you know, have been pending for a while. And one of the comments was, it's taken 2 years to get this corrected as far as the APCs losing their certification. So to just scrap the whole thing, you know, it affects things that are actually going to be beneficial to the APCs.
Well, and Madam Chair, members of the board, what I would remind the committee is that there was comment regarding the advanced practice registration renewal that is in the proposed rules, and the financial hardship that may cause APC doctors, you know, who want to take advantage of that. I think that is something that the board needs to consider at this time. I do remember the board at a previous meeting having a discussion about inserting language, and I'm not sure why it wasn't included, but inserting language into Part F that mirrors the reinstatement language that appears for other doctors of chiropractic. This is not the language.
Correct.
That's
Well,
not the
it should
language.
have been in there. We agreed to put it in. How did we miss it?
In the previous version, it was up to 1,500.
Mhm.
And at the
No.
last meeting, we changed that to match ACs, which is up to 1,000.
And we also put in there renewed within a 2-year period, which is to mirror the DCs, is what I'm saying.
Right.
So we did try to make it mirror the DCs requirement. And, you know, that.
Madam Chair, the board members, we do have Martha stating that it's not going to take 2 years to get another rules hearing on record. So I believe tabling this is the best route we should go to get everything cleaned up.
You want to make that
So,
motion?
Madam Chair, members of the board, what you could do is you refer it to the rules committee so the rules committee can work on it. Do whatever research that you want to do, figure out, you know, how long it's, you know, maybe give them a time frame, maybe schedule your next board meeting to give them that much time. And then if they have something ready and completed or final at that time and ready to present to the board, At that next board meeting, they present it to the board, and the board can actually vote to move to a real rule hearing on just that rule if you'd like. So you could probably do something next year.
All right, so somebody want to make that a motion?
I would be glad to. Make a motion that we table proposed rule changes to Chapter 4, Part 15 at this time, with the addition of adding either a APC board member or an APC at large at the next Rules Committee meeting.
Can you put in there something about, you know, giving direction to the Rules Committee to, you know, bring something to the board?
To give them time to research and work on it. One of the things I would ask is that RLD get involved in the process when you do have your rules committee meetings. I like the board administrator there at all times, and then I usually try to go if I don't have.
Well, the Rules Committee this time, when they met, the administrator, the team leader, and the assistant attorney general were part of that. So I would just assume that would be.
Is that good enough?
I don't know, give it another shot.
You didn't get a second, so you get to start over.
Or maybe you just want to say, table it to give the rules committee time to research and work on new language, and hopefully have something prepared for the next board meeting.
Madam Chair, as our Assistant AG had recommended, that also an advanced practice physician, either on this board or at large, be part of that Rules Committee. Because currently they are not on the Rules Committee. And that's what I'm going to put in the motion. I make a motion that we table Chapter 4, Part 15 of this rules hearing with
And send it back to the rules committee.
and send it back to the Rules Committee, who should have the presence or invite a APC from the board or from APC member at large as part of this Rules Committee investigation.
Can we add that?
Sure.
I'll second it.
Do we want in the motion that it should also include, I don't know, do leadership, pharmacy board, or whatever?
That's up to you, you don't have to have it in there, but if you want it in.
I think it's
Well,
good.
I think as far as the discussion goes, I think it'd be wise to have some sort of oversight from the other boards,
Do you want to put that in the motion?
if we need to.
So, Member Frackwell, I think you need to offer a friendly amendment to Member Pendleton's initial motion. I would recommend that you amend Member Pendleton's motion to include either some partnership or discussion with the Board of Pharmacy, the board, the medical board, and whoever else was mentioned in RLD's memorandum.
I make a motion, a friendly
Pharmacy
motion
board, medical board.
to add exactly what you said. Can you say that?
Yes. You can say so moved.
So moved.
All right. Do
Can
we
you
have
make
a
the
second?
amendment before we've,
Yes, you make an amendment before you have the discussion.
Then we can discuss now. Okay, now,
There's no second.
do we need a second on the friendly amendment? Do we have a second for the friendly amendment?
Or Dr. Pendleton needs to accept the amendment.
Dr. Pendleton, do you accept the amendment?
yes.
Now you
Okay.
can move forward.
Discussion?
Don't have a second yet. You second
Oh,
this?
there is a second.
We do not have a second, that's right. Do we have a second?
that's.
I'll second that. No, he offered a friendly amendment.
So now we have discussion, so.
Yes, now we have discussion.
Discuss how this day is going. Is this the only part of this, these changes that we're tabling? Or is this whole thing tabled?
No, the whole part 15.
Just 15.
Just
The rest
15.
of it is all getting changed
Yes.
so far. Now I understand.
Okay. So, any further discussion? All those in favor?
Aye.
Any opposed? All right. Moving on to part 16. So fast. All right. Chapter 4, part 16. Parental Responsibility Act compliance. Just the change of the name of the board. Do I hear a motion?
I make a motion to accept Chapter 4, Part 16 as it is written.
Second? Any discussion? All in favor?
Aye.
Chapter 4, Part 17, supervision of interns and housekeeping. Do I hear a motion?
I make a motion to accept Chapter 4, Part 17 as it is written.
Second?
I'll second that.
Any discussion? All those in favor?
Aye.
All right, chapter 4, part 18, practice procedures. We have just, we have housekeeping and then the addition in 16.4.18.9C, definition of dry needling. Do I hear a motion?
I accept chapter 4, part 18. I move the motion to accept chapter 4, part 18.
Do I hear a second?
I'll second.
All right, any discussion?
I just have a question. So I see that Part C, 18.9, Part C is just added.
Yeah.
Just, I mean, is that something that needs to be there, or?
Yeah, it comes up all the time. The question comes up all the time as to
What question?
dry needling.
Meaning,
Chiropractor
can we do
allowed
it
to
or
do
not?
dry needling, and what's the difference between dry needling and acupuncture? It comes up fairly regularly, so
So this is a rule just stating that chiropractors can dry needle,
it's given a definition of what it is.
and that it
Yes.
can be done by a chiropractor. Okay.
We don't have anything that, in our rules that